Welcome to the Human Dignity by Design podcast, where we explore tech law in context and discuss how law and technology can and should be designed to respect human dignity. My name is Jan Trzaskowski, and I'm here to share research, thoughts, and ideas on tech law and policy, including the role of fundamental human rights as guiding principles in business and beyond. The first 12 episodes of this podcast are an audiobook version of my 2021 book, Your Privacy is Important to Us, which explores how to restore human dignity in data-driven marketing that relies on artificial intelligence. In this episode, you will hear the fifth chapter of the book, which is an introduction to marketing law, which is also known as unfair competition law. Thank you for listening. Chapter 5. Marketing Law. Technology, media, and marketing are closely related, as technology is an important building block for media that is either financed through marketing or developed as a vehicle for marketing, including advertising. In the e-commerce directive, this was recognized in 2000 in recital 29, which stated that commercial communications are essential for the financing of information society services and for developing a wide variety of new charge-free services. As mentioned in Chapter 3, from a trader's perspective, marketing serves the legitimate purpose of influencing consumers' preferences by means of information and conduct in order to increase profits. Thus, the trader informs actual and potential customers about his products, understood in this context as including both goods and services, as discussed below in the context of digital services. From a societal perspective, marketing plays an important role in the function of markets, in which customers are expected to make efficient decisions, that is, decisions that match their individual goals, values, and preferences, based on their experience, knowledge, and available information, including, in particular, the trader's advertising. Individual traders may have an incentive to present their products and offerings in a light as favorable as possible, for instance, by emphasizing the advantages and downplaying the disadvantages. Consumers, on the other hand, are interested in finding the products and deals that best suit their goals, values, and preferences. This disparity in interest and incentives is the reason for the necessity of market intervention in the form of marketing law. The consumer's evaluation of products and offers may be based on parameters such as price, quality, service, and reputation. Advertising and other commercial practices are an important source of information to consumers, and truthful marketing is therefore important for markets to work properly. The role of commercial practices in consumers' decision-making is recognized in the Unfair Commercial Practices Directive, which is discussed below, as it focuses on whether a commercial practice causes or is likely to cause the average consumer to take a transactional decision, in a broad sense, that he would not have taken otherwise. To a large extent, decisions to purchase are based on information offered by the trader by means of marketing, recognizing that many other sources of information are available, including professional reviews and other sorts of peer reviews. In that regard, marketing serves an educational purpose, informing consumers about the availability, features, qualities, and price of products, and thereby allowing consumers to make choices that match their preferences. Misleading information and aggressive conducts may be a problem not only for consumers, but also for other traders who provide products or offerings that the consumer would have purchased had he not been provided with misleading information or exposed to the aggressive conduct. To allow consumers to take decisions in accordance with their individual goals, values, and preferences, transparency and the absence of manipulation are required, as we discuss in Chapter 8 and Chapter 9, respectively. A trader may also suffer from other traders' marketing that exploits his goodwill. Thus, marketing law is closely linked to competition law and intellectual property rights, including trademark law. By the means of trademark law, a trader can obtain exclusive rights to certain uses of a trade name, whereas competition law concerns cartels and the abuse of a dominant market position. Neither collusion nor dominance is a prerequisite for the application of marketing law. It applies to all traders. As in the case of data protection, the harmonization of marketing law also serves an additional purpose of removing obstacles to trade in the European single market. As will be clear from this chapter, many aspects of marketing law are fully harmonized, meaning that, as supported by the e-commerce directive, a trader in most cases only has to comply with the marketing law of the country of origin. The two main sources of marketing law in the European Union are the Unfair Commercial Practices Directive and the Misleading and Comparative Advertising Directive. The primary focus in this chapter is on the former directive, which deals with business-to-consumer commercial practices. Issues pertaining to the sending of unsolicited electronic mail are regulated in the e-privacy directive, introduced in the previous chapter. This marketing practice is closely linked to privacy, as discussed in chapter 10. Similarly, practices such as doorstep selling and unsolicited phone calls also entail an element of privacy infringement. Advertising, marketing, and commercial practices. A number of names and definitions for various sorts of marketing have been developed in the EU's acquis over the years. The most recent and broadest being commercial practices found in the Unfair Commercial Practices Directive. The Misleading and Comparative Advertising Directive regulates advertising, and the e-commerce directive regulates commercial communication. The most important difference between advertising, commercial communication, and commercial practices is that the latter also includes conducts, whereas the other directives are limited to information. 1. The Unfair Commercial Practices Directive. 1.1. Scope of application and interpretation. In order to be covered by the Unfair Commercial Practices Directive, the practice must be commercial in nature. That is, it must originate from a trader, and it must be directly connected with the promotion, sale, or supply of his products to consumers. The fact that it must originate from the trader means that, for instance, third-party reviews of the trader or his products in the media are not included, unless they are being used by the trader in his promotion. The Unfair Commercial Practices Directive applies to business-to-consumer commercial practices, which is a deliberately broad concept encompassing practices carried out before, during, and after a commercial transaction. The concept is defined in Article 2.1d as any act, omission, course of conduct, or representation, commercial communication, including advertising and marketing, by a trader directly connected with the promotion, sale, or supply of a product to consumers. Political marketing, as well as a trader's interaction with his investors, falls outside the scope as long as the intention is not to promote the trader's products. However, operating a commercial service that consists of mediating, for instance, political information, does constitute a commercial practice. The Court of Justice has consistently maintained that the Unfair Commercial Practices Directive is characterized by a particularly wide material scope, and that the act in question must clearly form part of an operator's commercial strategy and relate directly to the promotion thereof and its sales development. The act or omission on the part of the professional need not be recurrent or concern more than one consumer in order to be a commercial practice within the meaning of the directive. It follows from Article 3.2 that the directive is without prejudice to contract law and, in particular, to the rules concerning the validity, formation, or effect of a contract. This means that, for instance, the validity of a contract is not affected by the directive in cases where a contract is concluded following an unfair commercial practice. This does not, however, mean that the use of unfair contract terms cannot be considered an unfair commercial practice. Besides the proposal for the directive, guidance can be found in the Commission staff working document. 1.1.1 Digital Services and Digital Content. With the New Deal for Consumers Directive, digital service and digital content were added to the Unfair Commercial Practices Directive's definition of products in Article 2.1c, that now reads, product means any good or service including immovable property, digital service and digital content, as well as rights and obligations. With the insertion, the definition is aligned with the Digital Content Directive, but has no significant effect on the Unfair Commercial Practices Directive's scope, as it focuses on the commercial nature of the practice, regardless of the shape or form of the product. With the New Deal for Consumers Directive, the scope of the Consumer Rights Directive, which regulates contractual rights for consumers, was expanded to also apply when the consumer provides or undertakes to provide personal data instead of paying a price in money. The issue of paying with data is touched upon below in the context of purchases and payment, and more elaborately dealt with in Chapter 9. 1.1.2 Taste and Decency. Recital 7 provides that the Unfair Commercial Practices Directive does not address legal requirements related to taste and decency. This exemption must be understood in light of the directive's purpose to approximate laws concerning unfair commercial practices harming consumers' economic interests, as introduced in the context of consumer protection in Chapter 3. It seems reasonable to assume that taste and decency must be interpreted narrowly, but the exact scope of taste and decency is not settled in case law. It is clear from case law that this exemption may be used only in situations in which the action taken by a member state is based solely on taste and decency, which for instance could concern national rules on protecting human dignity, preventing sexual, racial and religious discrimination, or on the depiction of nudity, violence and antisocial behavior, as discussed further in Chapter 10. Thus, member states may regulate practices that do not concern consumers' economic interest, such as practices that are only undesirable for moral or cultural reasons. The protection of privacy is, at least primarily, a matter of taste and decency, and thus exempt from the Unfair Commercial Practices Directive. However, as should be clear by now, the processing of personal data has the potential to affect the economic interests of consumers, which is an argument for applying the Unfair Commercial Practices Directive to data-driven marketing alongside the GDPR. The latter solution resonates better with the deliberately wide scope of the Unfair Commercial Practices Directive. Doorstep selling, which we will revisit in Chapter 10, offers a good illustration. Doorstep selling may be undesirable for reasons of both privacy and the protection of consumers' economic interest. Intuitively, a national prohibition of doorstep selling cannot be justified under taste and decency, as it also concerns the protection of consumers' economic interests. From the above-mentioned Recital 7, it is provided that solicitations in the streets might be undesirable for cultural reasons, and that member states, accordingly, should be able to continue to ban commercial practices in their territory in conformity with community law for reasons of taste and decency. This seems like a good argument for maintaining a national prohibition of doorstep selling. The question is now addressed in the New Deal for Consumer Directive that amends Article 3.5 of the Unfair Commercial Practices Directive to allow for member states to adopt provisions in the context of unsolicited visits by a trader to a consumer's home, provided the provisions are proportionate, non-discriminatory, and justified on grounds of consumer protection. According to Recital 55, this is meant as a clarification. This clarification does not account for the fact that taste and decency falls outside the scope of the Unfair Commercial Practices Directive, and that consumer protection, which must be the justification, includes economic interest. Recital 55 further states that national provisions should not prohibit those sales channels as such. It remains unsettled whether, for instance, doorstep selling may be prohibited by a member state with the sole aim of protecting the privacy of citizens, which undoubtedly falls under taste and decency and, thus, outside the scope of the Unfair Commercial Practices Directive. However, it is clear from item 25 of the blacklist that personal visits to the consumer's home is regulated in the Unfair Commercial Practices Directive and thus lies within its scope of application. 2. The prohibition of unfair commercial practices. Article 5.1 prohibits unfair commercial practices, and Article 5.2 sets out 2 cumulative requirements that must be fulfilled for a commercial practice to be deemed unfair. Thus, a commercial practice is unfair if it is contrary to the requirement of professional diligence and it materially distorts or is likely to materially distort the economic behavior of the average consumer with regard to the product, hereafter referred to as economic distortion. The layout of this general prohibition is important in order to understand the structure of the directive, even though most cases are likely to be determined by the more specific prohibitions concerning misleading practices, aggressive practices, and blacklisted practices. These provisions are dealt with below. Annex 1 of the Unfair Commercial Practices Directive contains a list of 35 blacklisted commercial practices that shall apply in all member states, and which, according to Article 5.5, may only be modified by revision by the directive. The blacklisted practices are the only commercial practices that are considered unfair per se, that is, without an assessment of the requirement of professional diligence or economic distortion. In practice, one must, in order to determine whether a commercial practice is lawful, firstly consult the items on the blacklist, secondly consider whether the practice is misleading and/or aggressive, and thirdly consider whether the practice is otherwise contrary to the requirement of professional diligence. If the practice is considered to be otherwise contrary to the requirement of professional diligence, economic distortion must also be considered. If the practice is found to be misleading and/or aggressive, it must only be determined whether the practice causes or is likely to cause the average consumer to take a transactional decision that he would not have taken otherwise, hereafter referred to as economic effect. Such an analysis of the economic effect or distortion is not required for blacklisted commercial practices. 2.1. The requirements of professional diligence. Professional diligence is defined as the standard of special skill and care which a trader may reasonably be expected to exercise towards consumers, commensurate with honest market practices and/or the general principle of good faith in the trader's field of activity. The requirement must be understood as a standard for due care to be exercised by traders in general, ignoring concrete intent and negligence. Commercial practices that are either misleading or aggressive are as such contrary to the requirement of professional diligence. The International Chamber of Commerce has drawn up an advertising and marketing communications code. This code may serve as inspiration for determining the requirement of professional diligence, as it is designed to establish a sound ethical framework to govern marketing practices worldwide based on twin goals of fostering consumer fairness and trust and the freedom of commercial communications. The requirements of economic distortion and professional diligence are cumulative in Article 5.2, meaning that the requirement of professional diligence merely carves out commercial practices that are in fact likely to materially distort the economic behavior of the average consumer. It is assumed that the vast majority of the practices which would be defined as unfair under the general prohibitions are either misleading or aggressive. However, the possible interplay with the protection of privacy, including personal data, seems an obvious situation to invoke the general prohibition of unfair commercial practices. This is pursued further in Chapter 8. 2.2. Economic effect. The second requirement concerning economic distortion, material distortion of economic behavior, is defined in Article 2.1e as using a commercial practice to appreciably impair the consumer's ability to make an informed decision. It is a further requirement in the definition that this impairment is likely to cause the consumer to take a transactional decision that he would not have taken otherwise, that is, economic effect. Distortion of the average consumer's economic behavior thus constitutes the core of the directive. Except For the 35 blacklisted commercial practices in Annex 1, a commercial practice may only be considered unfair if it causes or is likely to cause the average consumer to take a transactional decision that he would not have taken otherwise. The requirement entails that any decision directly related to the actual or potential purchase of a product is covered by the concept of transactional decision. Transactional decision is broadly defined and includes potential decisions concerning whether or not to buy or complain about products and on what terms. This concept also covers decisions directly related to such purchase decisions, including the consumer's decision to enter a shop, which indicates a relatively low threshold as to the effect or loss inflicted on the consumer. Deciding to use a service that is offered free of charge, including by downloading an app, must also be considered a transactional decision. It seems reasonable to assume that clicking on an online advertisement is sufficient as well. 2.2.1. The average consumer. The average consumer plays a significant role in the directive, as the distortion of his economic behavior or transactional decision is required for the prohibition of a commercial practice that is not on the blacklist. From a linguistic perspective, it could seem like an oxymoron when it follows from recital 18 that the average consumer test is not a statistical test, because average is in fact a prominent concept within statistics. In that vein, it should be emphasized that the Court of Justice of the European Union has, with what appears as ease, given opinions on how the average consumer is expected to behave in various situations, notably without any discussions of a psychological, economic, sociological, or mathematical nature. This underlines that the average consumer is a normative abstraction, setting a standard for not how consumers do behave, but how they should or are expected to behave. It has been suggested that emphasizing that the average consumer test is not a statistical test could be understood as abolishing the use of statistical empirical evidence as a means of proof, but this has not been confirmed by the Court of Justice of the European Union. In the context of the Misleading and Comparative Advertising Directive, the Court of Justice of the European Union has allowed national courts to order an expert's opinion or commission a consumer research poll for the purpose of clarifying whether a promotional description or statement is misleading or not. Notably, this does not change the fact that the analysis is an abstraction, because the court will have to determine the validity of the result and convert the data into a normative threshold for what can be expected by an average consumer. More specifically, this second leg of the prohibition focuses on whether the practice in question is capable of affecting the economic behavior of an average consumer who is reasonably well informed and reasonably observant and circumspect, taking into account social, cultural, and linguistic factors. Thus, this requirement is to be perceived as a standard for due care to be exercised by the average consumer. Recital 6 provides that it is in line with the principle of proportionality, which says that the directive only protects consumers from the consequences of unfair commercial practices that are material, but also recognizes that in some cases the impact on consumers may be negligible. In a case concerning the possibility of participating in a price competition associated with the purchase of a newspaper, the Court of Justice of the European Union established that, for at least part of the public, the possibility of participating in a competition represented a factor that determined the purchase of the newspaper, meaning it was a relevant factor in the economic effect assessment, and that it could cause the national court to establish economic effect in the case. However, the court emphasized that it does not necessarily follow that a sale with a bonus constitutes an unfair commercial practice within the meaning of the directive, as it must also be verified whether the practice in question is contradictory to the requirement of professional diligence. It follows from Article 5.2 that the average consumer should be determined based on the group that the commercial practice reaches, is addressed to, or is directed to. It is not clear when and how these three often different criteria apply. In practice, however, this may not be particularly relevant, except for vulnerable groups as discussed below, as one must consider the legal abstraction of an average consumer who is not an actual person, but rather a standard for how consumers are likely to react in the case of a particular commercial practice. In essence, reference should be made to the persons to whom the commercial practices are applied. 2.2.2. Vulnerable consumers. The Unfair Commercial Practices Directive contains a provision aimed at preventing the exploitation of consumers whose characteristics make them particularly vulnerable to unfair commercial practices. This protection is, however, limited to groups of consumers who are particularly vulnerable to the commercial practices because of their mental or physical infirmity, age, or credulity. In these cases, the protection requires that the commercial practice is assessed from the perspective of the average member of that group rather from the normal average consumer. It is not a requirement that the vulnerable group be specifically targeted by the commercial practices, meaning that all commercial practices that may distort the behavior of members of the group of vulnerable consumers must be assessed in the light of this provision. It is important to emphasize that a significant limitation is found in the requirement that the trader should reasonably be expected to foresee the distortion of the vulnerable group's behavior. In the context of consumers' economic interest, the possible vulnerabilities are vast and may cover all situations in which consumers make inferior choices relative to their preferences due to a commercial practice. In the context of the Unfair Commercial Practices Directive and the consumer's efficient choice, the vulnerabilities mainly relate to their ability to gather and comprehend information and the likelihood that they may be more credulous than the average consumer. For instance, the unemployed may be more susceptible to being influenced by a hope of future income, and the ill more prone to believe in possible cures. 3. Misleading commercial practices. Misleading commercial practices may be misleading actions or omissions. However, these two provisions are so closely related that both will often apply to the same commercial practice. Similarly, it may sometimes be difficult to draw clear distinctions between when a commercial practice is aggressive and when it is misleading. 3.1. Misleading actions. Article 6 defines when a commercial practice must be regarded as a misleading action. It should be emphasized that a practice may only be unlawful if it has economic effect, as discussed above. The most straightforward situation is when a commercial practice contains false information and therefore is untruthful. However, even when information is factually correct, it may still be misleading when the practice deceives or is likely to deceive the average consumer in any way, including its overall presentation in relation to one or more of the following elements: the existence or nature of the product, the main characteristics of the product, the extent of the trader's commitments, the motives for the commercial practice, and the nature of the sales process, any statement or symbol in relation to direct or indirect sponsorship or approval of the trader or the product, the price or the manner in which the price is calculated, or the existence of a specific price advantage, the need for a service, part, replacement, or repair, the nature, attributes, and rights of the trader or his agent, the consumer's rights, including the right to replacement or reimbursement, or the risk he may face. Another set of misleading actions is found in Article 6.2, under which a commercial practice is misleading if in its factual context, taking account of all its features and circumstances, it has economic effect as discussed above. The misleading actions in Article 6.2 include any marketing of a product, including comparative advertising, which creates confusion with any products, trademarks, trade names, or other distinguishing marks of a competitor. Non-compliance by the trader with commitments contained in the codes of conduct by which the trader has undertaken to be bound. Any marketing of a good in one member state as being identical to a good marketed in other member states, while that good has significantly different composition or characteristics unless justified by legitimate and objective factors. 3.2. Misleading omissions. The prohibition of misleading omissions is closely related to information requirements, but it relates only to material information that the average consumer needs based on the context in order to make an informed transactional decision. The commercial practice must be assessed in its factual context, taking into account all its features and circumstances, as well as the limitations of the communication medium. There are no firm guidelines for how information should be provided or displayed, but it follows from Article 7.2 that it is a misleading omission if the trader hides or provides in an unclear, unintelligible, ambiguous, or untimely manner such material information as referred to above. As for misleading actions, it is also a requirement that the commercial practice has economic effect as discussed above. Information requirements established by community law in relation to commercial communications, including but not limited to advertising or marketing, are regarded as material, including the information requirements found in the E-commerce Directive and the Consumer Rights Directive. Article 6 of the E-commerce Directive states that commercial communications, promotional offers, and promotional competitions, games must be clearly identifiable as such, and that the conditions for qualification and/or participation must be easily accessible and presented clearly and unambiguously. These rules are also closely related to the general information requirement discussed above. 3.2.1. Limitations in time and space. Limitations of the communication medium must be taken into account when determining whether material information is omitted. This is elaborated on in Article 7.3, which reads, "Where the medium used to communicate the commercial practice imposes limitations of space or time, these limitations and any measures taken by the trader to make the information available to consumers by other means shall be taken into account in deciding whether information has been omitted." The measures taken by the trader to make information available to consumers by other means includes posting on a website. Even when a medium is limited in time and space, it must be assessed whether the general presentation of the commercial practices allows an average consumer to make an informed transactional decision, or whether, on the contrary, the commercial communication is, overall, likely to create a mistaken perception of the offer, and thus constitutes a misleading action, as discussed above. 3.2.2. Identification of commercial intent. One of the fundamental requirements of marketing law is that marketing should be identifiable in order to raise the consumer's awareness of such exposure. This is particularly relevant in context in which the consumer has no expectations of being exposed to marketing, for instance, in editorial content, as opposed to next to and clearly separated from such content, which is what is usually expected. This aspect of marketing is addressed in Article 7.2, under which it is considered a misleading omission if the trader fails to identify the commercial intent of the commercial practice as it is not apparent from the context, and provided that this causes or is likely to cause the average consumer to take a transactional decision that he would not have made otherwise. In this vein, the use of native advertising has flourished, that being a form of advertising that matches the form with the function of the media in which it appears. Examples include a newspaper ad that looked like an editorial article with byline and all, and promoted stories on Facebook. Using native advertising is in itself not misleading, but it must, all else being equal, meet the requirement of indicating its commercial intent in order to ensure that the average consumer is not being misled. The provision concerning limitations in space and time concerns only the disclosure of information, and thus does not detract from the requirement that the commercial intent must be apparent, at least from the context. In addition, it must also be emphasized that the provision only applies to misleading omissions, and that such a commercial practice also may be considered a misleading action, taking into consideration the overall presentation, even provided that the information is factually correct. In an online context, this should be read in conjunction with Article 6.1a of the E-commerce Directive, which provides that commercial communication shall be clearly identifiable as such. This provision does not contain a requirement of economic distortion. However, if the average consumer is likely to identify particular marketing as such, it may be assumed that it is clearly identifiable. In addition, it must, according to Article 6.1b of the E-commerce Directive, be clearly identifiable on whose behalf the commercial communication is made when an information society service is used as medium. 3.2.3. Invitation to purchase. Further material information is specified in Article 7.4 in the case of an invitation to purchase, which is a particular concept for commercial practices that comprises commercial communication that 1. Indicates the characteristics of the product, for instance by verbal or visual reference, and 2. The product's price, for instance an entry-level price. Besides the indications concerning price and a product, these indications should also 3. Enable the consumer to make a purchase. Purchase in this context is likely to include situations where the consumer provides or undertakes to provide personal data, as discussed above, either directly or by means of analog interpretation of the general prohibition of misleading omissions. It is not a requirement that an order should be placed within the context of the commercial practice. Hence, a newspaper ad or website without an order form may be considered an invitation to purchase within the definition of the Unfair Commercial Practices Directive if the information provided is sufficient for an average consumer to mentally make a decision to purchase the particular product. If the commercial practice fulfills the requirement to constitute an invitation to purchase, the following information is regarded as material, if not already apparent from the context. The main characteristics of the product, to the extent appropriate to the medium and the product, the geographical address, and the identity of the trader. The price inclusive of taxes, or where the nature of the product means that the price cannot reasonably be calculated in advance, the manner in which the price is calculated. The arrangement for payments, delivery, and performance if they depart from the requirements of professional diligence. For products and transactions involving a right of withdrawal or cancellation, the existence of such rights. For products offered on online marketplaces, whether the third party offering the products is a trader or not, on the basis of the declaration of that third party to the provider of the online marketplace. 3.3. Disclosure of ranking criteria. The new Consumer Deal Directive introduces an Article 7.4a specifying what is material information in the context of ranking, which is defined as the relative prominence given to products as presented, organized, or communicated by the trader, irrespective of the technological means used for such representation, organization, or communication. Article 7.4a of the Unfair Commercial Practices Directive concerns general information on the main parameters determining the ranking of products presented to the consumer as a result of the search query and the relative importance of those parameters as opposed to other parameters. The information must be made available in a specific section of the online interface that is directly and easily accessible from the page where the query results are presented. The provision does not apply to providers of online search engines regulated in the Platform to Business Regulation, which in its Article 5 provides for a similar information requirement between traders and online intermediaries, as discussed in Chapter 9. Article 7.4a is corroborated by the following blacklisted commercial practice that is prohibited per se. 11a. Providing search results in response to a consumer's online search query without clearly disclosing any paid advertisement or payment specifically for achieving higher ranking of products within the search results. According to Recital 20 of the new Consumer Deal Directive, the provision also applies to indirect payment, including accepting additional obligations towards the search provider or increased commission or compensation. However, payments for general services, such as listing fees, etc., are only payment when they are dedicated to achieving higher ranking. The provisions do not apply to mediation of information that is not triggered by a search query, but inspiration may be drawn in that context, as mediation inherently is a matter of giving relative prominence to content, including products, and is often triggered by behavior. The above-mentioned provisions are not intended to detract from the general provisions of misleading actions and omissions. And as we will discuss in Chapter 8 and Chapter 9, ranking based on personal data is also linked to the protection of privacy, including personal data. 4. Aggressive commercial practices. While the two provisions on misleading commercial practices focus on the information provided or omitted, the provisions on aggressive practices focus on the conducts exercised in the trader's course of business. It is a misleading commercial practice to provide wrong and misleading information, whereas providing information that may be irrelevant to the situation, such as disparaging remarks about a competitor, should be assessed under the provisions concerning aggressive practices, as long as the remarks are made in a business-to-consumer context. Aggressive practices concern also the use of, for instance, certain sales promotions, such as premiums, bonuses, and commercial lotteries. A commercial practice is aggressive if in its factual context, taking account of all its features and circumstances, it significantly impairs or is likely to significantly impair the average consumer's freedom of choice or conduct with regard to the product. This prohibition concerns impairment by harassment, coercion, including the use of physical force and/or undue influence. As for misleading commercial practices, the aggressive practices must have commercial effect in order to be unlawful. In determining whether a commercial practice uses harassment, coercion, including the use of physical force and/or undue influence, account must be taken of A. Its timing, location, nature, or persistence. B. The use of threatening or abusive language or behavior. C. The exploitation by the trader of any specific misfortune or circumstance of such gravity as to impair the consumer's judgment, to influence the consumer's decision with regard to the product. D. Any onerous or disproportionate non-contractual barriers imposed by the trader when a consumer wishes to exercise his rights under the contract, including rights to terminate a contract or to switch to another product or another trader. E. Any threat to make any action that cannot legally be taken. In the context of data-driven marketing, it is important to determine the extent to which personalized marketing is deemed aggressive. The provision explicitly comprises coercion, which is a form of manipulation, and undue influence, including the exploitation of a position of power to apply pressure even without using or threatening to use physical force. The focus must be on whether the commercial practice in question significantly limits the consumer's ability to make an informed decision, which is pursued in Chapter 8. 4.1. Privacy-infringing commercial practices. As mentioned above, doorstep selling is a commercial practice that also may be undesirable for privacy reasons. The same is the case when traders approach consumers by means of telephony and email, which is regulated in the e-privacy directive. From an unfair commercial practices directive perspective, privacy-infringing commercial practices seems to fit best under aggressive practices that include harassment. Recital 40 of the e-privacy directive provides that safeguards should be provided for subscribers against intrusion of their privacy by unsolicited communications for direct marketing purposes, and that in some cases the emails in addition may cause difficulties for electronic communication networks and terminal equipment. The primary regulation of unsolicited electronic messages is found in Article 13 of the e-Privacy Directive, which is both part of the common regulatory framework for telecommunication and lex specialis to the GDPR discussed in Chapter 4. Personalized marketing entails the processing of personal data, and it may be argued that the decision to use a particular email address is primarily data processing, whereas the actual sending of an electronic mail is primarily a commercial practice. However, due to the broad concept of processing, the latter act will also in itself constitute processing of personal data. Thus, traders have to comply with both marketing law and data protection law. It should be noted that making persistent and unwanted solicitations by telephone, fax, email, or other remote media, except in circumstances and to the extent justified under national law to enforce a contractual obligation, is considered to be an aggressive blacklisted commercial practice under the Unfair Commercial Practices Directive that maintains a focus on unwanted in contrast to unsolicited solicitations, and is based on an opt-out model rather than the stricter opt-in model found in the e-Privacy Directive. Unsolicited communication is understood as messages to which the subscribers or users have not given their prior consent. Article 13 provides that automatic calling machines, fax, and electronic mail may only be used for the purposes of direct marketing with respect to subscribers who are natural persons and who have given their prior consent, that is, an opt-in solution. Consent should be understood in accordance with the definition in the GDPR as discussed in the previous chapter. An electronic mail is defined in Article 2.1h as any text, voice, sound, or image message sent over a public communications network that can be stored in a network or in the recipient's terminal equipment until it is collected by the recipient. Article 13.2 contains an exemption concerning communication by electronic mail, where the trader has obtained from its customers their electronic contract details for electronic mail in the context of a sale of a product. In that case, the trader may use these electronic contact details for direct marketing of its own similar products. However, the customers must be given a clearly and distinctly opportunity to object, free of charge and in an easy manner, both at the time of their collection and on the occasion of each message. This exemption entails that a trader, in the context of an online purchase, may pre-check a box indicating that the consumer wishes to receive emails from the trader, which is notably not akin to consent. Provided that the text is clear, it allows the consumer to uncheck the box and thereby indicate that he objects to such communication. From a commercial point of view, it may be a better option to pursue the opt-in approach and thereby avoid the dissatisfaction of consumers who unwillingly end up on a mailing list. It does not matter whether the sender is a trader or not. The important part is whether the purpose of communication is direct marketing, meaning that the communication must at least be made on behalf of a trader. Therefore, a trader cannot pay private individuals to send a message that he is not allowed to send himself. The directive contains no definition of direct marketing, which may be understood as any solicitation aimed at individuals with a view to making a sale at some point. Thus, the sending of an email with the purpose of obtaining the recipient's consent to send direct marketing material must also be considered to be done for direct marketing purposes. To the extent that unsolicited commercial communication by electronic mail is permitted, member states must ensure that such commercial communication is clearly and unambiguously identifiable as soon as it receives by the recipient. This is followed up by Article 13.4 of the e-Privacy Directive, which prohibits the sending of electronic mail that 1. Fails to comply with Article 6 of the e-Commerce Directive, 2. Does not have a valid address to which the recipient may send a request that such communication cease, or 3, encourages recipients to visit websites that contravene that Article 6 of the e-commerce directive. 4.1.1 Messages in social media services. The e-privacy directive regulates communication that is carried out in a public communication network, as defined in the Telecommunication Framework Directive. The regulatory framework for telecommunication concerns transmission services, that is conveyance of signals, but not content services, for instance web-based content, which are regulated by other instruments, including in particular the e-commerce directive concerning information society services. There is not much doubt that social media services must be considered as an information society service, and thus are also web-based content falling outside the scope of the telecommunications directives, meaning that messages in social media services are not covered by the prohibition. Thus, unsolicited commercial communication provided through social media services must be assessed in the light of item 26 of the blacklist, which prohibits persistent and unwanted solicitations by telephone, fax, email, or other remote media, except in circumstances and to the extent justified under national law to enforce a contractual obligation. It is noted that this prohibition is without prejudice to the e-privacy directive. 5. Blacklisted commercial practices. The blacklisted commercial practices in Annex 1 are the only commercial practices that are prohibited without the need to assess the economic effect or distortion. In other words, the blacklisted commercial practices are prohibited under all circumstances, that is per se. These 35 per se prohibitions protect all and not only the average consumers. It has been argued that the items, to a large extent, only restate what would be prohibited under the general principles of unfair commercial practices, and that the blacklist, despite the intention to provide clear prohibitions, is not sufficiently precise because of its use of vague notions, which is likely to pose important problems in practice. 5.1. Free. It follows from item 20 of the Unfair Commercial Practices Directive's blacklist that it is unlawful to describe a product as gratis, free, without charge, or similar, if the consumer has to pay anything other than the unavoidable costs of responding to the commercial practice and collecting or paying for the delivery of that item. Free, in this context, is likely to be understood as without payment. In line with the discussions above, it could be argued that purchase should include situations when the consumer provides or undertakes to provide personal data instead of paying a price in money. The concept of free is further discussed in Chapter 9. 6. Full harmonization. Article 4 of the Unfair Commercial Practices Directive provides that member states cannot restrict the freedom to provide services or the free movement of goods for reasons falling within the field approximated by the directive. The directive provides full harmonization of marketing law within its scope, that is, providing both floor and ceiling for national regulation. It is, however, clear from case law that this directive only sets the exact framework for how member states may regulate commercial practices within the scope of the directive. Therefore, and despite the full harmonization, there will be divergences in how member states assess key concepts used in determining whether a commercial practice is unfair. Due to the full harmonization, it is important to understand the scope of application, as the directive limits the member states' possibility to regulate within this scope, thus also setting the boundaries for when a trader may solely rely on national marketing law under the directive. For information society services, the e-commerce directive provides for a broader country of origin principle, which also includes aspects that fall under taste and decency. The limitations of the member states' ability to prohibit commercial practices without a case-by-case assessment applies only to prohibitions that pursue consumer protection as their sole or partial objective. Thus, the directive does not apply to national law which does not at all pursue objectives related to consumer protection, conferring the above discussion of prohibitions established solely for privacy reasons. 6.1. Assessment by national courts. Under the Misleading and Comparative Advertising Directive, the Court of Justice of the European Union itself settled issues concerning whether an advertisement was misleading, rather than leaving the final decision for the national court, when the evidence and information before it seemed sufficient and the solution clear. It is, however, emphasized in Recital 18 of the Unfair Commercial Practices Directive that national courts and authorities will have to exercise their own faculty of judgment to determine the typical reaction of the average consumer in a given case by taking into account social, cultural, and linguistic factors. However, they must have regard to the case law of the Court of Justice of the European Union. There is no similar reference to the national court's faculty of judgment in the context of professional diligence. This could mean that professional diligence is a common, autonomous standard for all member states, which may make sense given that professional diligence is further elaborated on, that is harmonized, in Articles 6 to 9 concerning misleading and aggressive commercial practices. However, these provisions themselves require assessment of what behavior can be expected by the average consumer, which, at least in these situations, provides an argument for national assessment in accordance with Recital 18, that is, to determine the typical reaction of the average consumer in a given case. In case law concerning the directive, the Court of Justice of the European Union has left the assessment of central issues to the member states, including the requirement of professional diligence, providing sufficient information to consumers, and consideration of whether national law pursues consumer protection objectives. In recent case law, the Court of Justice of the European Union has become clearer in its guidance, but has still left central assessment to the national courts. Thus, the Court of Justice of the European Union seems to be reluctant to make such assessment in its decisions, and it is obvious that the full harmonization will not completely eliminate differences in the member states' assessment of commercial practices. In the media print case, the Court of Justice of the European Union found that a national court may establish material economic distortion when at least part of the public concerned had their economic behavior distorted. The fact that the Court of Justice of the European Union, despite opportunities, has not made such assessments supports the impression of reluctance to interfere with national assessment. Therefore, the courts of various member states may treat similar commercial practices differently, although the member states may not, according to Article 4, restrict a trader from providing products that are subject to commercial practices, which in turn are in accordance with national law. 7. The interplay with data protection. Arguments from consumer protection law may play a role in data protection law, as the latter requires the processing of personal data to be fair and lawful. The reverse is also true, as consumer protection law aims at striking a fair balance between traders and consumers, a balance that can be affected by the trader's processing of personal data. Thus, data protection law constitutes an important pillar of consumer protection law. The non-binding guidance by the Commission suggests that personal data, consumer preferences, and other user-generated content have a de facto economic value and are being sold to third parties, and that failure to inform the consumers that the data he is required to provide to the trader in order to access the service will be used for commercial purposes could be considered a misleading omission of material information. When it comes to professional diligence, that is, the special skill and care which a trader may reasonably be expected to exercise, this is likely to include issues pertaining to privacy. For instance, the United Nations Guidelines for Consumer Protections concerning principles for good business practices provides that businesses should protect consumers' privacy through a combination of appropriate control, security, transparency, and consent mechanisms relating to the collection and use of their personal data. Similarly, it could be argued that the reasonable, well-informed, and reasonable observant and circumspect consumer must be aware of how personal data are recorded and used for behavior modification. He must understand his preferences with regard to not only economic decisions, but also decisions relating to how he administers his attention and time in general. It remains fair to say that data protection law provides for a much tighter, more coherent, and more robust framework to further its aims compared to the field of consumer law. Marketing law remains fragmented, and the scope of application is unclear with regard to the taste and decency. The Unfair Commercial Practices Directive shares the principles of empowerment, transparency, and proportionality with the GDPR, but the Unfair Commercial Practices Directive does not contain similar requirements for legitimacy and accountability. Thank you for joining the Human Dignity by Design podcast, where we explore tech law in context. In the next episode, you can listen to the 6th chapter of Your Privacy is Important to Us, which is about human decision-making, including issues pertaining to agency, psychology, bounded rationality, and bounded willpower. Music for this podcast is composed and performed by Thomas Roth. My name is Jan Trzaskowski.